Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case.
Is that correct?
That's literally not true.
Oh, for Trump's sake. I didn't ask you to interrupt me.
Good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. It's good to have you all here. Welcome. Let's see. If I can find this. Let's see. Pin message. There it is. Boom. Well, I'm in the wrong corner. That's why. I was missing. Let's run back down here for a minute. All right, big welcome to Fire Girl, handmade by Wendy. First in chat today. Thank you very much, Fire Girl. You are first in chat, which means you are first in line for a big punishment. Everything IP-related worldwide is now your responsibility to repair, fix, maintain, and educate on the proper use of. That's not a wrong way to end a sentence. I don't know what is. Great. We're super excited about this. You've won before. You're going to win again, and you're going to do great today. Good morning. If I sound a little funny, it's because I'm half dead. I don't know. Yesterday I started feeling bad, and by the end of yesterday I was just like, I got hit by a train. I think I slept 3 hours last night, and it was a bad 3 hours. It was not a good 3 hours, and with like lots of wake-ups in between. Eyes itch, runny nose, sneezy, cold, fever, the whole works. I've got it all. So this microphone cover will be thrown away after today, and I will get a new one. So it's brand new. Yeah. All right. It's time. Yes. But we've got some things to do today I'm super excited about. So we're going to have a couple things this morning. Obviously, we're going to celebrate some birthdays. And we've got a little bit of some quick court things to watch and a longer one, and maybe a little bit of court hopping. But I'm super excited about all that. So let's get this underway. And first of all, let me just say, Britta Aller, member for 29 months. Thanks for the wonderful support these past few months. Great place to watch True Crime with friends who are like family. Mods and RA are amazing. Britta Aller, you are a true OG. Welcome. So glad to have you here. Would not be the same without you. Thank you. All right, we have some birthdays, and we're going to sing to you now with my low voice because I can. AC's Wildflower. I figure somebody transferred it to me over the burner phone. So somebody gave me this cold over the burner phone. It could happen. No, it can't happen. But all right, welcome. Let's see. Got my sutures out for my shoulder replacement yesterday. Have to wait another 4 weeks before physical therapy. Well, hopefully by the time that 4 weeks is over, the pain will be gone. My physical therapist had a sign in his office on his wall that said, it's like the no pain, no gain. And he's like, no, pain is not gain in this situation. If it hurts, stop. It hurts for a reason. It's your body telling you, don't do that. So hopefully you have a similar physical therapist. That was a long time ago. Man, that was after my car. It was also a shoulder situation. I got in a car accident. Soon after I got married. That was my favorite truck ever. It was the Toyota. It was like SR5. It was before the SR5, the model right before the SR5. I had a supercharged Toyota SR5, chrome roll bars, KC lights, lift kit, huge tires, everything that a boy could want in a little tiny pickup truck. And totaled it, messed up my shoulder. Anyway, we're all good now. We're back. Kelly H., thank you very much for the birthday cake this morning, celebrating some birthday stuff. And Josh has come with the birthday names in alphabetical order again. I love it. I love it. We have Ashley, Chris, Corey, Joan, John, Lily, and Miss Beezy. So we're going to sing happy birthday to all these wonderful people while we get the events kicked off for today. So everyone join with me. I'm going to need your help today. So sing loud. So everyone stand up, take a deep breath, shoulders back, project your voice to the back of the room. Blend your voice with your neighbor and warm up with me if you will. La, 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 la. Took a bit to find it, but we're there. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Ashley, Chris, Corey, Joan, John, Lily, and Miss Beezy. Happy birthday to you. I think my sick singing voice sounds better than my not sick singing voice. How is that a thing? Just have to catch a cold every time it's time to perform. It'll be great. Happy birthday, Ashley, Chris, Corey, Joan, John, Lily, and Miss Beezy, to everyone who's celebrating their birthday today. Have a happy birthday. I realize there are many wonderful days. Today is your special day. And I also realized that you could have celebrated this a million different places. You could have been with a million different people, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. Hopefully we can turn some of that joy back to you, make your day a little more special. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, and Cracker Barrel. Wow. Yeah. There we go. It's your birthday. Happy 7th to us. Yes, happy 7th. Crochet Nana, happy birthday. Yes. Dancers are doing their thing. Oh, yeah. It's a wonderful day to celebrate. It's a good week. It really is. It's a good week. Good things are happening. I love how encouraging 80s is with all the dancers. So good. I'm just enjoying the tunes. Drum solo to finish. Everyone join with me on the drum solo. Let's finish this with a bang. Mine was sort of half-hearted, so I appreciate all you all drumming as well. Happy birthday. Happy birthday. Well, before we get too far, we need to put an earworm in your head, and it's going to be from our good old friend Judge Middleton, who was great at doing just that. So let's get a little morning hello from him for a couple minutes, and we'll jump over to where we're going to go with Mr. Soto and some spice.
Good morning, everyone. Good morning. Our early adopters. We've got some people in the call room, and AI and Firefly and Jim and Tom are all early. Good morning, folks, and good morning to you. It is a good morning.
Yes, it is.
I did manage to ride my bike this morning. It was 66 degrees before the downpour. It's rained real hard after I got home. Might be my last one for a while. It's supposed to be like 34 degrees the next couple of days. It might frost.
Barely above freezing. 2 degrees above freezing.
So it's a beautiful day to be here. I did finally finish that Ashley furniture store, and it was hard. Anyway, we've got a lot going on this morning. We've got pre-exam conferences in a little bit. There are a dozen of those. We've got about a dozen arraignments and pretrials. And I wanted to say hello to a couple people. I got a real nice card from Brian and Christy. Thank you for that. We had some visitors yesterday. They kind of got some interesting stuff. Tim and Donna from Richland by way of Missouri and a bunch of other places. I sent them to Yoder's for lunch. I hope they had a good lunch
Yoder's
there. I send everybody to Yoder's for lunch. And so thank you to them. Mm-hmm. I'm still always dumbfounded that people come here to visit.
We were talking about
I think they're underwhelmed when they get here. But they were very nice people. I enjoyed talking to them a little bit. He's one of the guys that kind of sometimes leaves it on in the background. Today, I have a first line. It's an easy one.
Here we go.
Especially if you're a Generation Joneser like me from Middle America. This is one of those songs that there's a situation where nobody put those words together in that sequence probably ever. And you'll probably all know it. Even Lillian from Sweden might want to take a minute and listen to this bit of shared humanity where we all maybe at least acknowledge one piece of music. So I said it is easy, but nobody ever said these words before. So today's first line of the song is nibbling on sponge cake, watching the sun bake, all those tourists covered with oil.
There you go.
If you know it, you can sing it. If you don't, maybe look it up, listen to it. Our little shared piece of culture this morning.
A little bit of Jimmy Buffett for you.
In the courtroom, they both looked at me with blank stares. If I sang it, you'd know it. All right, I'll let this run for a minute while we wait for our public defender. Which case are you folks here?
Okay, that's as far as we're going to go with that one. A little bit of Margaritaville from Jimmy Buffett from the year 1977, the year I was born. It's going way back, but good times. Nibbling on sponge cake. All right. I love how he starts his morning. I need to get there. I need to get here earlier so I can actually chat with him a little bit because he has to turn off his chat. Obviously, he has a whole bunch of trolls that follow him and basically ruin his live stream every day. Which is terrible because every time he starts the live stream, he says hello to people, and there are people he's familiar with who follow him and have followed him for a long time. And they get in, and then the trolls find him, and they start ruining it, and he has to shut it down. And it's terrible that his morning always starts with people just being awful. But he does shut it down for court now because there've been problems. But anyway, just a great judge. All right, we have some spiciness to get to this morning. We sort of teased yesterday, and I'm going to actually cut a bit out. Hang on one second. All right. I think it's this one. Yeah. We're going to cut a bit out. We had at the Spencer hearing for Jose Soto Escalara, which is the hearing where the judge decides whether he's going to get life in prison or just the death penalty, as the jury recommended. They called in this witness who was sort of like a family expert, right? That she digs into your past and says, here are all the things that were wrong with your family. This is all the bad things that happened to you in life. There's intergenerational trauma that has affected you in these ways. This is how you were disadvantaged. This is why why we should look at you with pity right now and not impose the maximum sentence. So it's all for an effort to reduce the final, I guess, the outcome. Hang on just one second. Where's my super source? I need 4 to be MP1. Sorry, we're running some background stuff here. MP1 needs to be this. There we go. All right, so we'll get started here in just a moment with that. We're cutting out the part before the spicy bit. That witness talks for a long time, and yes, it's important, but we're not watching it for that reason. I'm going to be up here in this corner for this. Let's go ahead and bring you into court as it's beginning right now on 2 play. There we go.
Has had time to confer with Mr. Soto Escalera. Any further evidence from the defense?
Well, Judge, I did have some commentary to make and some argument to make. However,
Right. But outside of argument?
No more. Well, Mr. Soto Escalera wants to speak, Judge.
Mr. Soto Escalera wants to speak. Let me put this in both ears because it's not right now. Hang on.
My client would like to address.
Okay, he may make a statement either under oath or not under oath at his choosing, allocution or otherwise.
He's allocuting.
Okay, you may make a statement, Mr. Soto Escalera, at this time. Go ahead.
Thank you, sir. What I'm bringing to the courts to address is I have a conflict of interest. Mr. Thomas Burns. So I was asking for your permission, if possible, if I can get him removed from my case because I don't trust him.
Mr. Soto Escalera, trying to think of how to say this in a way that's most understandable.
He wants his lawyer removed from his
I think
case.
there's an expression, we're at the 11th hour. This is probably even beyond that. We're probably at 11:59 here. We're about to close all of the evidence in your case, which would be submitted to me with the jury's recommendation, whether you should receive the death penalty or life in prison. Counsel has already done his job. They've already completed their work on the case. Really, at this point, all that's left for them to do is argue to me. So I don't believe there's really any purpose in that at this time. Even if I were to grant your request, there's nothing left for counsel to do at this time other than to make argument to me, which quite frankly could be persuasive, but given the judge's function and where we are, as I mentioned, 11:59 metaphorically, there's really not much purpose in that. So from counsel, since it does affect counsel, does counsel agree with my observation on that particular point? I'm going to inquire Mr. Soto Escalera whether he wants to speak about the decision I have to make and give me input in that regard, because he has the right to do that. But that's separate and apart from what's being said now. Does counsel for the defense agree with my observation as far as, if this is a request to discharge counsel, where
Absolutely, Judge, and that
the horse is out of the barn at 11:59 p.m., I suppose would be the metaphorical.
The horse
correct.
is out of the barn.
To my client, I am not qualified to be on the case by myself because I'm only second chair qualified.
She's not death certified for first chair.
Mr. Burns has to remain on the case to the duration.
Right, and just for the record, we haven't heard the arguments yet, but there's been a substantial amount of mitigation put before me, both at the trial and additionally here today, that I have to consider and digest, and does not seem to me that there's any reason for me to discharge counsel at this time. More importantly, before you brought that up, Mr. Soto Escalera, you do have the right to make a statement at this time, either under oath or otherwise, that I would consider in making my determination in this sentencing proceeding. You understand you have that right to do that. Yes. And I was assuming that you were going to do that. I'm not saying whether you should or not. That's between you and your counsel. But I want to make sure that by me dismissing your conflict of interest issue, you don't take that as me dismissing your ability to make such a statement. Okay. Do you wish to make such a statement, or do you wish to talk to your counsel about whether you wish to do that at this time?
Pause for just 1 second.
The reason why I brought it up, Your Honor, is because something has surfaced.
Something has surfaced.
With a witness, and it was recorded in audio. This is why I'm requesting that I would have him removed. But if I can't remove him, I would like you to see what I'm speaking about, so you can understand.
Okay, we're going to pause for just a second. Mr. Soto Escalara is mad at not both his attorneys, just the attorney that did the closing for him, which honestly, I would be mad at him too, right? I didn't think that was a very effective closing. And it was terrible. He says something has come up just recently, and I've lost my confidence in my attorney, and I'd like him removed. The judge is literally, he's ready to rule. Okay, this is about where he's at. He's heard all the evidence, and he's like, okay, anything else? And he's like, yeah, can you remove my attorney? So this is just 11th hour doesn't begin to cut it.
With regard to that would be a decision in this very important context for your attorneys to make, whether to submit that issue to me as far as potential mitigation. And as I'm required to do, I would defer to their professional decision in that regard.
Enough, Judge. I'm going to lay it all out on the record, okay? I think Mr. Soto Escalara is hurting his situation. He's proceeding in ignorance on the advice of ignorant people. What he is referring to is a Zoom recorded deposition, the first such deposition I ever did in my life, with witness Lucinda Cook. This was done, I think, on a Tuesday when it was a court holiday, when we were in the midst of trial or jury selection. I'm not sure exactly where we were yet. And before Ms. Cook joined, there was a recording with chit-chat between me and Mr. Richardson about witnesses in the case, about the state of the case, about why I was calling witnesses and not calling witnesses, and complaining about somebody who had Ms. Minton's credit card and was going over the limits, and chit-chatting as counsel do between themselves waiting for a witness. And I don't think people understand the context of how attorneys talk to each other. I think that the witnesses who overheard this, Ms. Lucinda Cook and whoever else she communicated with, think that because this is a capital murder case, me and Mr. Richardson should be like this with our hands around each other's throats every moment. And we were not that way. We were chatting as counsel do in a case. And in a capital case especially, do counsel and adversaries have to communicate frequently and exhaustively to get the thing from start to finish done. That's all that it was. There is nothing in there that was inimical to Mr. Jose Soto Escalara's defense, and I defy him or anyone else to point to any action or anything that I did or said at any point in the preparation of this case or in the trial or in the penalty phase that was contrary to his interest. It's nonsense and bull crap, and that's what he's on about, Judge. So he can feel however he wants. He's an idiot. On this issue, at least.
In that regard, for Mr. Soto Escalara's benefit, the people who are here observing this proceeding, regardless of the court's sentencing decision, whether I impose a life sentence or a death sentence, there are appeals that take place directly and then indirect appeals which relate to assistance of counsel, whether the defendant received proper assistance of counsel.
Wow.
That's for a different day. I could see this coming up perhaps in that scenario on the merits to be figured out at that time as appropriate, which goes back to what I said before. The evidence is in, mitigation has been placed before me. So we're at that stage where I'm to consider that. Put differently, if Mr. Soto Escalara feels that Mr. Burns did not properly litigate his case for whatever reason, there will be a proceeding in that regard. But to be fair to Mr. Burns' respected counsel before the court, usually what has to be shown, or what would have to be shown, is something of substance, not just some idle remark we see from criminal defendants all the time, like, my attorney is working for the state, because look, they're smiling at each other and they're acting as professionals and not constantly cursing and berating each other and putting each other down. That's not the expectation of the court. In fact, we foster the opposite as professionals, that they get along, because once this case is over, they'll be on to a next case, and so will I. And so as professionals, they have to work with each other. But more importantly, as I mentioned at the outset, that is for another day. I'm directly focused on the extremely consequential and important decision I have to make, which goes back to whether Mr. Soto Escalara wants to make a statement regarding himself, the case, for me to consider. He does not have to, and it's not going to affect him negatively if he doesn't, but he has that right to do that. So there again, we broached a different subject. I don't want him to think that I'm not going to listen to that, should he wish to listen to make that statement. On the other hand, I'm not sure he has an intent to do that anyway. He just wanted to broach this subject.
Right, Judge, I think he
Okay.
said his piece and he has nothing.
Okay. All right. So it's not the first time I've had to tell the defendant or someone else. That's for another day. There is a right to have a motion for post-conviction relief with regard to your Sixth Amendment right to counsel. That's for another day, really, regardless of my decision here. So other than that, that concludes the Spencer hearing evidence from the defense. Any evidence from the state before argument?
No evidence, sir.
No evidence.
All right, so let's start off with the argument of the state. If you wish to make a summary argument.
And now he gets to argue.
You don't have to. I mean, obviously, I'm familiar with my role here. I want to dissuade you from that, but you do both have the right to make argument.
Defense goes last on this
to
one.
influence me in the way I evaluate the evidence.
Sure.
The way the aggravation and mitigation.
Yes, sir. I would just say that based on the extensive evidence that was adduced in the trial and the penalty phase, based on the aggravated factor findings of the jury, as well as the verdicts of the jury as a whole, the state request that the court impose 2 death sentences in this case on both counts. Thank you.
Thank you. And the defense, Mr. Burns.
Yes, I do have a few comments to make, Judge, in the nature of argument. Some of them addressing aggravators and some just in general. One of the things that needs to be considered and proved is that there was heightened premeditation in this case. I think certainly there was evidence that this case was planned and thought about at least for some days before the actual killing occurred. I don't know how extensive or how important the court would consider the testimony of the witness who indicated that Jose was interested in ghost guns, I think a couple of weeks before the killing. I don't know whether that manifests as an expression of an intent to do anything wrong. This was not a shooting or a gun crime. It did not arouse in the witness's mind at the time that there was anything nefarious going on. He thought that Jose might have been building a gun for sale. And so what we have here, the evidence in the case was that this was a pregnancy of many months duration that Jose objected to from the start, and yet
not the very
there was
start.
No evidence of any kind of intent to do anything wrong until only a few days before the actual event. And so I would ask the court to consider that. On this next issue, again, I don't like to tread here, but these are just unsavory matters to begin with. Regarding the aggravator of child under 12, I certainly do not dispute that that aggravator is correctly found. I do offer for the court's consideration that the manifestation of that aggravator in this case is as mild as could be. I don't want to state it any more bluntly than that, but what we lost here and what we mourn here in Josiah, we lose and mourn speculatively. There's no personality that has been evinced, and so I think that although that aggravator is properly found,
nobody knew him, so it's not a big loss.
Even more horrible. We have testimony from Raul Benasco relative to the court imposing a life sentence without the possibility of parole, which is what I'm asking for in regards to each victim. That Jose's been fined while he's been incarcerated for many years in a county jail, which is not designed for long-term incarceration. He would be a good prisoner. He has skills to offer. They work them hard in prison. Jose has skills to offer. I also want to ask the court to consider that the nature of persons who want to be executed should be such that Jose doesn't really fit the category. He has no prior criminal history whatsoever. This is a dramatic departure from nothing to a very horrible crime, but it is a crime of personal circumstances. It is not a crime of randomness. It is not a crime against strangers. It is not a crime where Jose indicates that he is some kind of danger to the community at large. It is a very particularized type of crime, again, wildly at odds with his nature that we heard from his family and that we heard from Dr. Schwartz, and his evidence in his lack of a criminal record, which I think is really quite astounding. And finally, I think I would be remiss if I did not remind the court that although the recommendation is for death, it was as close a call as could be possible, and I would ask the court to consider that also in leaning towards selecting that possibility for both counts. Thank you.
Thank you. Any response by the state?
Real little rebuttal.
In abundance of caution, let me ask a question to the state, and in part, this is just to avoid the appearance of us as with regard to the evidence that we glossed over anything. I have my own view of the evidence, and I'd certainly listen closely. I don't know that this was really fleshed out in argument before the jury, but with regard to the cold calculated, premeditated, aggravating factor, which was found by the jury beyond a reasonable doubt, is my perception of the evidence correct from the state's view in that it does appear that there was substantial planning fitting the definition? However, there was a variance between a lot of the planning and the actual way that the crime was committed, in the sense that there was a lot of talk of a gun, and then the murder occurred by different means, and which doesn't undo the aggravating factor, but it's something because I've never heard the state directly address that. I don't think the state directly addressed that with the jury, because it's kind of an aside, but just to cover every base, and because it was brought up by the defense, what is the state's view of the situation there with the evidence?
Yes, so the evidence, the way the evidence shook out was that there was a significant degree of planning in the days leading up to this, particularly beginning on August 21st of 2018. The defendant discussed using a firearm on multiple occasions, but the court is correct. At no time did the defendant ever discuss cutting her throat or hitting her in the head with a large blunt object, which was the ultimate cause of death in the case.
Since you just whack her once and be done with it.
Although there was much discussion, and I think he did go back and forth on the way he would kill her, I don't recall any specific statement regarding either cutting her throat or hitting her in the head with a large blunt object. He also did discuss using a second person, presumably a Alvarado. But again, there's no evidence that that was actually carried out.
And there was discussion, I have this in my notes, but just in an abundance of caution, there was discussion between the defendant and Mr. Alvarado in the garbage truck about the location of where the crime would occur.
Yes.
The route, the garbage route.
Oh, yeah, in several different conversations.
Right.
Yes, sir.
All right. Well, particularly given what was brought up with regard to counsel and so forth, I do want to commend the attorneys for their fine work. And no one can do that better than me, because it's right now squarely before me. Let me tell you where I am in the case.
Yes, please.
This is one of those situations where, as a judge, you could try to put the case out of your mind as much as possible. But I've found doing this that even when you think you're doing that, you're still thinking of this case. And I've been constantly thinking about it. I'm far along in my analytical process. However, more has been put before me today, particularly fleshing out other suggested mitigation and a few others that are also new suggested mitigation. So I have that to shore up, but I do intend to finalize my decision and announce my decision this Friday, which is the 10th at 1:30. There's a chance that I'm not done by then, but I think I will be done by then. There again, I'm far along, and I appreciate the doctor's report. I will review it in exquisite detail and dissect it along with my notes to make the final decision in this case. Either way, the decision of the court must be in writing. So I will announce the decision on Friday at 1:30, and we'll see you then.
Yes, sir.
Thank you.
Your Honor.
Thank you. Go off the record.
So that's where we leave it for Jose Soto Escalara. He will find out on Friday, in 3 days, whether the judge is going to go with the recommendation of the jury, which was by the narrowest of margins selected the death penalty as their recommendation, or if we're going to go to, if he's going to reduce it to life without parole, which would be what the defense is asking for and arguing for and has been fighting for all this time. All right, we have some court hopping, some court watching to do this morning. I'm going to try to make it all the way to lunchtime before I just keel over. so let's see if we can do that. Let's jump to Judge Dad.
I didn't hear that.
Are you there, Judge Dad? Hello? Oh, his courtroom's empty.
All right, I'm going to get off. Let me know when something's ready.
Yep, we'll just.
It's a nice chair. Yeah, it's a nice chair. Is that a new chair? I think one of these judges' chairs is like completely just trashed on the back. I think it's his. But nothing ready in Judge Dad's court. We can go up to Middleton, who was busy, hard at work this morning.
Sending me posted a $7,500 cash surety. He is not here. You have any contact with this defendant?
I met with him at the jail.
Oh, he's at the jail.
No. While he was at the jail.
Oh, and then he bonded out.
Yeah.
All right.
I had contact.
Yeah, thank you.
That's just the system in Florida. The judge makes the final call with the jury's recommendation. The jury makes a very strong recommendation, and generally the judge follows it, but there could be some mitigating factors.
I don't have a phone number. Record made. I'm going to do a bench warrant.
Still cracks me up, Legally Blonde, that you asked the judge where he got his chair.
Notice bond forfeiture.
Bond forfeiture. Man, just show up to court and you won't lose all that money.
Bonding company posted $7,500.
They're not going to be happy.
And a new bench warrant. $10,000 for surety. Good morning, Mr. Garn. Can you hear me?
Yes, Your Honor.
This is Judge Middleton. I'll be with you in just one sec. You had a felony matter this morning, possession of methamphetamine, and you waived preliminary examination in this matter, but there was also an old disorderly person charge hanging around. It's alleged that in September 23rd, let me actually pull it up.
It's like a special charge for elderly, disorderly people?
You were a disorderly person at West Chicago in Ottawa. Alleged you were yelling at people and intoxicated.
I'm guessing.
You've been in custody now.
Guessing alcohol might have been a factor there.
For 14 days. I would represent to you the same thing as I did with an earlier defendant. If you plead guilty to this charge, I'm going to give you 14 days in jail, credit 14 days, a minimum allowable fine concurrent with your other felony case. Do you understand?
Yes, I do.
All right. Are you willing to plead to being a disorderly person in Sturgis on September 23rd?
Yes, Your Honor.
Anybody threaten you to get you to do that?
No, but I was not made aware of it until just now.
I didn't know.
Yeah, the ticket's been lurking around here. I just wanted to try to deal with it today and get one more thing off your plate. Okay. You understand that if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury. There will be no trial. Do you understand that? I do. If you had a trial, you'd have the right to be represented by an attorney. If you could not afford an attorney, get appoint one for you at county expense.
I understand, Your Honor.
If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would also have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. You did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless they were able to prove your guilt beyond a reasonable doubt. All right. Other than what I told you about what I'm going to do for the sentence, did anybody promise you anything to get you to plead to this charge? Or threaten you?
No.
All right. Were you there in Sturgis on that day, September 23rd, yelling at people and being intoxicated?
I was intoxicated. I don't exactly remember yelling at anyone specifically, except maybe the officers on scene, but...
Officers. Yelled at the officers.
All right, that's probably good enough.
They witnessed it.
14 days, credit 14 days. I'm going to make it concurrent with your felony case, which is 251635 FH. And the fine is $0, but the state costs are $125 or 2 additional days, which will get swallowed up by the time you're already doing. All right, Mr. Garnis, one last thing you got to deal with. We'll deal with your methamphetamine case in the circuit court. This disorderly person case is done, and you're good to go. All right, thank you, sir. All right, let's see if we can see Robert Kovac and then Billy Donahue. We're done with Mr. Garn. All right, thanks. We have a visitor today, and Mr. Collin of Coolin with Collin has come in to visit us this morning. Thank you for stopping by. Thank you, Luke. These make me on my life easier.
You're welcome, Judge.
All right, Mr. Garn's got other problems than yelling at the cops while you're drunk is probably enough for a disorderly person.
We might go and jump to another one really quickly. Let's jump down here for just
all right. Well, let's get started. Our darn system must be slow, Miss Bashir. I don't doubt you sent it, but let's get started. And I do have the photos at least. We'll use try to work.
I'll resend it again.
Yeah, I don't think it's your end, but I appreciate it. But I think it's the county. I think it's our. For some reason, it's running really slow.
Okay. This is an issue over a retirement party.
Started for both of you. Why don't both of you raise your right hands, Miss Davis Taylor and Miss Bashir? There you go. Do you swear from the testimony you're about to give will be the truth?
Yes.
Okay. Miss Davis Taylor, this is your claim for services not provided on a retirement party, looks like.
Yes.
And I did pull out the exhibits 29 and 30, the two photos of that for you. I don't think it's your end, but I appreciate it. But I think it's the county.
Fix the
I think
audio.
it's our.
Hang on.
For some reason, it's running really slow.
Okay.
I had to back up.
Let's kind of get started for both of you. Why don't both of you raise your right hands, Miss Davis Taylor and Miss Bashir? There you go. Do you swear from the testimony you're about to give will be the truth?
Yes.
Okay. Miss Davis Taylor, this is your claim for services not provided on a retirement party, looks like.
Yes.
And I did pull out the exhibits 29 and 30, the two photos of that for you. I was also received in the file, I've got St. George Banquet Center. I don't know that that's significant per se. Is that how somehow tied into this?
It was only significant in the fact that I rented the hall from 8 a.m. that morning.
Okay.
That was all that was for. Yeah.
Okay. So if it becomes significant, I do have it, but I don't think it will be relevant, really.
Okay.
And so you hired Rashida Bashir to do, I guess, the decorations for you?
Yes.
Is that what it is? Okay.
Yes.
And was there anything signed, or is this the agreement that on these two photos?
No, there wasn't nothing signed. That was the agreement, and then it just explained how I was supposed to make the payments, and the payments were made through Zelle, and you have those as well. Pictures number 31 and 32 are pictures of my payments that went from Zelle to her.
Okay. 31 and 32 are payments. Let's I guess I don't know that Miss Bashir, are you complaining that you did not receive payments at all?
No.
Okay, so we got payments.
Yeah.
Okay,
yes,
so
it was paid in full. It was paid in full.
So why don't you
that's half the problem.
Miss Davis Taylor, help me out with what you did not receive. I know it was $1,800 agreement.
$1,800 for
and then
decorations?
There's a list of items, and I kind of went through them a little bit.
It's a lot of decorations.
What
I'm seeing a
items
little crepe paper and maybe a
did
cake.
you not get?
The welcome sign was mediocre at best. I mean, it was very disappointing. This was my husband's retirement party. He had retired with 48 years and 3 months. And so I really wanted to do it very nice. And I don't feel that I got that. She had asked me for pictures of him to be sent to her so that she can use them on the table. And that's picture number 2 of the text message that she sent me. And she only used one picture. The gift box was a total disaster. It looked like a child had did it, and that's picture number 36. And then
I'm sorry, what was number 36? That's the
gift box.
Gift box.
Gift in a box.
The gift box, yes.
So what was in the gift box? Is just you didn't like the designing of the gift box?
No, it's just it wasn't right. It had wrapping paper on it, okay, but it was so loose, it wasn't professionally done, and then it was a slot in the top where you're supposed to put the cards in, and you couldn't get the cards in because the slot was so small, and so it was just, it wasn't right. And then the biggest thing is I had rented the hall from 8 a.m. on August the 2nd until 1 a.m. August the 3rd. And and those would be pictures number 6, 7, and number 14, which I sent her the code on how she can enter into the hall and she can do what she needed to do and get it done. And
get her done.
That she wasn't done. Matter of fact, I asked her when was she was going to be done with that. And she said I should be done by 2, but if I'm running a little late, it'll be 2:30 at the latest. Okay. And needless to say, at 6 o'clock, when my husband's event started, she was still there trying to decorate the hall. And
she has things to say.
I was very embarrassed because I put a lot of thought and money into this, and I didn't get what I expected. And I had then the photo backdrop where people go and take pictures with the honoree. I told her, if you look at text messages 13 and pictures 17 and 18, I told her that I wanted black, gold, and white balloons, and she said that would be no problem. But needless to say, there were not any. The balloons were mediocre. They were very few. They were sparse. And I sent pictures. I have pictures in there that show you what the backdrop looked like, which was picture number 34 and 35. And picture number 33 is what I was expecting, something similar. It didn't even have to be the same. That is not my issue. But it wasn't anything close to it. And
contract,
and
though.
later I addressed her in text message, and I told her that I wasn't pleased with what she provided. And she said she was sorry that I was disappointed in it, but she said she didn't like the way Kelly. Now, this name Kelly is the person who is in charge of the hall. She didn't like the way she looked at her, so she got the balloons that she still had to put up. She took them and put them in her vehicle and drove off. And I'm like, you didn't like the way Kelly looked at you. I mean, she said she looked at me demeaning, and my point is that she didn't hire you. I'm the one who hired you, and I had an expectation of what it is that I was going to receive, and that's not what I received. And so she said that, well, I didn't like it, so I left. Unacceptable. And I can't speak for Kelly, but I would think that whatever she felt had nothing to do with her. And if she felt some kind of way, she could have came to me because I was there at the hall. And she did not do that. She just left.
This was yesterday, this case.
So a lot of what I was expecting, I did not get.
Okay.
Buyer's remorse.
I'm sorry, you said Kelly? Some gal named Kelly. Was this at the end just before the retirement party started? Is that what you're telling me?
Yes, because see, what happens is, like anybody that's doing work, like our DJ, they were provided with the code that they can come into a certain door and set up and everything. Yeah. She was provided with a code to come in and do what she needed to do, and as early as 8 that morning, but she did not. The person that was in charge of the kitchen had the code, And so Kelly came back prior to the start of the party to open the main door for the guests to come in. And that's why she was there. And she said she didn't like the way she looked at her.
Okay. And was the actual time that Ms. Bashir was supposed to be there setting up, was there a time talked about? I mean, I know that. Did you tell her at least that the retirement party was starting at 6?
She knew that. Yes, I did tell her that it started at 6 and that the hall was available to her at 8. I found out that she also had another event that day. And I think that that's probably the reason why I didn't get what I was what I paid for, is because she may have overextended herself to a point where she didn't have enough time to do what she was supposed to do for me. The other thing is she had 2 young boys, 13 and 14, 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 there to help her that from appearance, they appeared not to know what they were doing, and they did more sitting as opposed to working.
Okay.
And so she really was basically there by herself, other than those two boys that was, I mean, yeah, I was there.
Were you, I was just gonna say, and you were there. What time did you get there? What time were you there?
Oh my goodness. Well, I don't know exactly what time I got there, but I would say about 2:30, because she said that was the latest that she was would be, and that if she was not done by 2:30, she would give me a call. Needless to say, she never ever gave me a call to say that she was running late or anything.
I think she's running right now.
What time if you showed up there about 2:30, right?
Mm-hmm.
What time did Miss Bashir show up then?
She was there prior to that.
Oh, prior to you getting there. Okay. So she was there. You walk in and she's working, I guess. Is that sound about right?
Yes.
When
I'm anticipating that, well, okay, at 2:30, you should have been done at 2, and you said if it was going to be running late, it would be 2:30 at the latest, but you're still not done. Now I'm still there, and it's 6 o'clock, and Kelly says, Mary, do you want me to open up the doors? And I'm like, she said, because people are waiting outside. And I said, yes. I mean, that's not fair to my guests.
And what time was that about? What she said, do you want me to open up the doors?
6.
When was that? That
6
was
o'clock.
at 6. Okay. Okay. Does that, I'll give you a chance to tell me anything beyond that, but is that pretty much a summary of what you're complaining of?
Yes. I didn't get what I paid for.
Okay.
And I also have a statement, I'm sure you see it already, from a person that witnessed the whole thing. Yeah.
Yeah, and I can't really use that without them here.
Okay,
so
that's fine.
So
that's fine.
Let me hear from Ms. Bashir, and then we'll see where we're at. Ms. Bashir?
Good afternoon, Judge Goggins. I want to start this with saying I do understand one's perception is their reality. Okay. Miss Mary Davis Taylor reached out to me about doing her husband's retirement party. We went back and forth for a while on what she wanted, what she didn't want. She explicitly told me that she did not want anything fancy. He's simple. He's a simple guy. You know, I didn't have to do, these big tall centerpieces, different things for the party. Okay, that was number one. As in reference to the welcome sign, the welcome sign was a welcome sign that I do a lot of times depending upon the invoice pricing of the event. Now, she reached out to me by text and told me she thought it should have been in a picture frame. Well, she didn't pay for that type of a welcome sign in her package. I have a message here where she told me she had sticker shock when I sent her the first invoice. She wanted a setup for 300 guests. She had a budget of $1,500. That is $5 a person, okay? I can't do that. I sent her the invoice. She said, I guess she couldn't afford it. I resent her another invoice where she took the amount of guests down. And in that invoice that I sent, I didn't even attach my setup and teardown fee to it. And I explained that to her. I have a text message where I ate the cost on that because I didn't put it into this invoice. So be it. So she really didn't pay the amount that was the actual amount, but I ate that and I was okay with it. It's business. It was my mistake. I'm going to just go ahead and do it.
She told me that. What was that now? That was what were you eating the cost of?
I didn't, in the invoice that I sent her, the revised invoice, I did not implement the setup and teardown fee, which is my cost for doing the event. Basically, when you do an event, they have to rent the items from me, and then I attach my cost for, everything, which I have a text message where I sent her what decorating entails, okay? It's a lot of mental, physical preparation, cleaning, transporting, supplies,
Could be
formulating, and all of that, okay? It's a lot. So I let her know, when she was bothered by the price, what it entailed to try to get her to understand.
Okay.
So she accepted the revised invoice. Now, she sent me a message about 2, 3 days later saying that, oh, I'm tired. It was a big event, blah, blah, blah. I was very pleased with the event, except for outside of the tablecloths and decoration. She didn't like the welcome sign. She didn't like the card box. She didn't like the balloons. I sent her $100 back as a goodwill gesture because I did not want a disappointed client. She felt like that $100 was not enough. She received every item on the contract, on the invoice. There was nothing on the invoice she did not receive. I also added decorative napkins on my part to make the event come together. Now, that is also out of my pocket, but I wanted to make sure the event was nice, even though she wanted it simple. When you're an artist, it's very hard to constrict your artistry for simple. So a lot of times when you decorate events, you'll add things for people and they won't even know it, okay? Sometimes, or they won't know ahead of time, they'll know it when they get there. And that's what I did. I spoke with a guest that attended the retirement party the next day. I didn't even know she was there. She complimented how nice it was. She said she asked her husband, did he want a retirement party like that? And he said no. Now,
sorry.
I guess
No.
I guess this is sued. I'm being sued for expectations and feelings because on the notice that I was served, it says she felt like she got the short end of the stick. And because I had another event that weekend. That's not what happened. What happened is that she paid for simple and she received simple. She sent me a long text message telling me what she could have done because she did a party, blah, 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 blah. And I didn't respond to that message because I felt that it was a rant and a vent, to me. And in my mind, I'm thinking, well, it would have been okay if you could have just done your own event, especially after I've went through all this hard work, spending my money, ordering, losing money, not attaching my setup and tear down fee. That was almost a slap in the face. Okay, the young males who work for me on all my events. I can send you photos of my events. They are 17 years old. When she might have saw them sitting, that's okay sometimes, but they were not doing anything, and I was not doing it all by myself. She was not even there the whole time. Okay, she didn't like the backdrop. I set the backdrop up first in one spot. Her son-in-law told me that I had to move it. I had to break it all down, re-put it back up, put curtains on it, blah, blah, blah. That took extra time, okay? Because I guess they were having a slideshow, and that's what the slideshow was going to be, but she didn't tell me that ahead of time. She also didn't communicate to me that she told me she paid extra for them to open up the hall early. She never communicated with me. And I have a text message where she said to me, it was no need for me to let you know this. Yes, there was a need. When you reaching out for a decorator for an event, that's what you're supposed to communicate so that I know that I could have gone in at 8 o'clock, but I did not. It was a very simple event. It wasn't a huge, huge event. It was a nice amount of people, but it doesn't take, 8 hours or so to do. And usually I just go in at will at my own time. And as long as I'm done before it starts, that's how it goes. There were no guests coming in when I finished. My pastor, I met him outside in the parking lot. He was pulling up and he wasn't in the building, and I was going out from decorating. I don't know what guests she was talking about. There were not people sitting down. The DJ was still setting up. They were still preparing food. The slideshow people were preparing the slideshow. Now, I did send her money back for the balloons because I could have done the balloons fuller, but Kelly at the hall, she was on my back. She walked up to me. She told me, you've got to be done now. The doors are opening up at 5:30. You have to be done now. And I said, well, Miss Kelly, no disrespect. There's people still setting up around the DJ, blah, blah, blah. I want to finish. About 15 minutes later, I'm attaching the balloon. She stands with her arms folded, glaring at me. I turned around, I looked at her. I kept doing it, and she just kept staring at me. And I explained that to Miss Mary, that I felt that was disrespectful what Kelly was doing. Okay, and so then I sent her $100 back because of the balloons not being as full. I don't know why I'm on the Zoom call, because she received every item that was in the invoice. I don't know why I'm on the Zoom call, and I can't believe that she is saying that it was mediocre, because you asked for simple. And there was more than one picture. I have pictures of her husband on the tables. They were double side made. I paid a company, Zuddles, on Bristol Road I designed them, and they printed them out double sided. Okay, they were different photos on each side. I don't know. What questions do you have for me? Because I'm listening, and I can't believe that.
I do have one question with regard to the balloons. What you're talking about, the balloons on the backdrop?
So there's some curtains that she told me she wanted, curtains and some balloons. She never sent me a sample. I have all the text messages printed out. So for her to expect something she never showed, I don't know how that can happen. Okay, usually our clients that I deal with, they send me inspirations or inspos. She did not send me one for a balloon art. She just told me balloons and curtains, because she didn't want it fancy. She didn't want this. She didn't want that. I mean, the whole road was, it was kind of rough. I'm not going to tell you, but I stayed professional. I stayed patient and all of that. But to sit here to hear her speak of me and my business like this, it kind of gets to me a little bit, but that's okay. I just want to get this over with, because I couldn't believe it when the man walked up to me at my job and served me the paperwork.
She's mad she got served.
We can't hear you, Judge.
Oh, you can't hear me?
Okay. No.
Oh, I kind of moved away a bit. What with what I guess I'm thinking of as a backdrop, it says "Happy Birthday" on it, and it's got balloons around it.
That's something I was sort of like expecting to get. That's not what
That's the one you expected.
Okay,
yeah, but I don't have a photo of that. She never sent it to me.
And you never asked for one.
I don't.
You never asked for anything. Anything that I tried to get together, I always had to initiate. Look, I'm not attacking you personally. Let's be real clear about that.
I don't want to go back and forth either.
The first thing that I said to her in my text message was, I really, really liked the way you did the tables. Now, the things that I had a problem with, those were the things that I specified. So I tell you one other thing. I never ever said anything about you or your company, because that is not what I'm about. I am not trying to defame you or anything like that, because that's not what I am. That's not who I am.
I take that.
Yes. And so no one knows anything about what you and I are, dealing with right now.
I'm not worried. I'm not worried about anybody knowing anything, Miss Mary. It's just that I can't believe that you're sitting there.
All I wanted was what I paid for.
I gave you everything. I gave you everything.
You did not.
Well, we don't want to go. I don't want to go back and forth on this public court hearing. I don't. That's not professional. It's not. I don't want to do that. I don't want to do this.
Hold on, guys. I'm going to start muting here, but I don't mind venting a little bit, because sometimes that just needs to happen. But so that one photo I got, that was just an idea of what you thought was going to be there, and then
something remotely similar.
And then the one, Miss Bashir, that you did do, apparently. It looks like curtains are fairly tall. I guess it's probably 7, 8 feet tall.
Maybe 7. I had it on one spot before, and I moved it to another side, and I did not get to make the balloons as full.
Yeah,
I agree there, and I sent her $100 back for that. And that's not, I don't know if that's in your notes or paperwork, but I did send her money back. Now, I want to know how she's comprising $500. out of that, of a card box, some balloons, and because here's the thing, Judge, with balloons. Most people say it's just balloons. No, you have to buy the balloons, you have to blow them up, you have to have equipment, you have to formulate them, you have to twist them up, you have to buy bags to carry them in, they have to be transported. All of that. It's not just balloons, but I gave her $100 back as a goodwill gesture because I felt like I was wrong and at fault. But nowhere else do I feel like I owe her anything.
Okay,
Not monetarily. Like monetarily, I already lost on this event because I added napkins and I messed up and didn't put my fee on the invoice. And to me, once you make that mistake, you just eat it. And I did that. Now, her bringing in another event has nothing to do with her event. That baffles me too. That has nothing to do with it to me.
Yeah.
I think she's looking at her expectations, and expectations are just that, yours. I did not receive any. It's so I can't believe it. I just want to go ahead and deal with
so
it.
let me just ask you this then. The other one, the balloon thing, I can kind of work through. I do have the a picture of the retirement box, the box where envelopes were to be placed in. It does look not very professional. It looks like it's.
I can't see it. I don't know when she took the picture.
I was going to ask when was the picture taken?
After
it was taken, let me see. I'm sorry.
Trying to show you
days later.
Bashir on here. It's going to be kind of hard for me to get it up.
Okay.
Some of it gets to be subjective, but I can kind of show. You know what? Let me take that background off of mine.
Oh yes, we get to see his real background. Here we go.
I can do that.
Sees his basement.
Video. I don't know if I'm going to be able to do that or not. Can you see?
You can't, but that's not on the table. The tablecloths were black.
Okay.
That's taken afterwards, so I can't tell you what was done to it, anything. That was afterwards. The table was on. Are there flowers on the box?
There's a couple in there's 2 flowers on the top of it at the corners, and then there's one at the bottom of
okay, so I can't see from the photo, but that wasn't taken at the place because the tablecloths were black velvet.
Yeah, it's sitting on the floor. That I will take.
The box was not the picture of the box was not on the table. I did sit it on the floor to take the picture. Yes, sure. I did.
Okay. So if to me, if that box was an issue, when you look at the invoice, I would give her the price of the box back, but I want to know how she's getting to $500. And the welcome sign was fine. The welcome sign was fine.
No, it was not fine. You can't, I mean, that's your opinion.
On my end, it was fine because I've done a plethora of welcome signs. Usually the fancier the welcome sign, the more the ticket price is. And people specify that so I can charge them what it costs for that. You don't come back after and tell me what I could have done because you didn't ask for that. And you also definitely did not pay for that. And you also told me.
And when was I supposed to tell you all of what I did not like when you got when you took the balloons, got in your car and your vehicle and left? So there was no opportunity for me to tell you, I don't like this, I would like something different or whatever, because I wasn't given it. You never even came to me and said to me, Kelly is giving me some kind of look, which I don't know. So I don't know.
You know what, Miss Mary? If you really want to know, everyone was dry on your end, including you. When you walked into the building, it was never hello, hi, okay, blah blah blah. It was nothing. And then another thing, when I came into the building, all the tables that I needed to be covered for food had all the food on it that you guys brought in, so I couldn't work with that area. Okay, so there was never a cordial, a nice, anything.
Yeah, that's a problem.
Anything pleasant. It was
the
very
food's there
much
before the decorator.
Very standoffish, but I'm okay with that. I've been a hairstylist for 30 years. I deal with a lot of energies and personalities. I still do what I have to do, okay? And I kept going. when you reach out to a person with that you want something personally done, there are things that you should communicate. I asked. You told me simple. He's simple. He doesn't want much. He doesn't have to have this. You
How
wanted
much was
all low,
the
low. You
guys?
wanted all low centerpieces. I told you. Well,
How much was hold on, guys. How much was the welcome sign?
the welcome sign. I'll have to go back and look at the invoice. It might have just been inside. Let's see. Hold on. Welcome
How
sign.
much was? Go ahead. I'm sorry.
That basic welcome sign is about $35-$40 because I have to design.
She lowballing everything because she wants.
Lowballing. Did you say low? Did you say lowballing?
She doesn't.
Yeah, I lowballed myself on giving you the
you go
invoice
ahead
price.
and speak because when I was trying to speak, you interrupted. So you go ahead.
Yeah, lowballing is exactly the word for what I should have charged you for the event. I explained to you that you didn't get the full price. You told me you told me you had sticker shock. What did you expect for $1,500 for that many guests? What did you expect for $1,500 for that many guests?
Let's
I'm not understanding.
I paid $1,800. Let's be clear.
For how many guests? For how many guests?
200. 1,800.
So that's not even. What is that?
So you're talking about 15, but I paid $1,800. Let's be clear about that.
Because you did not get my fee involved. I did not get my fee.
I'm gonna start muting everybody except lost control of this thing. I try to give you some chance to kind of vent a little bit. I got both of you muted. Let's just leave it at that. Miss Davis Taylor, how much did you pay for that welcome sign? I'm gonna unmute you again. Go ahead and unmute. No, you gotta unmute again. This is where we're gonna have issues.
You asked me what did I pay for it?
No, yeah, what was the cost to you? What did she charge you for that welcome sign?
It's not like that. It was 18. Okay. It was.
Was that just part of the whole?
Yes, and it's what was included in that 1,800. And this is the thing. I feel like she's lowballing and saying that. So if she didn't like the box, the box is $35, and if she didn't like the sign, this is that. But what I'm saying is that this was a once in a lifetime kind of event. This is something that I really wanted to do to honor my husband for his 48 years of working for General Motors. And so I put into what I felt like I did not get. That's how I came up with the $500. And then there's a $40 processing server fee. Then there's a $30 filing fee. And then all the pictures that I provided with you so you could see the text messages that we had going back and forth, and also the pictures of what actually I received and what I did not.
Okay.
And so
hold on. Let me talk a little bit here.
Okay.
The card box was you list well, at least it was listed as $40. So that one I have a price on. That's the only reason I'm asking about the
But that's her price. You know what I'm saying?
But I understand, but that's what you sent me. That's what you sent me. So I'm guessing that card box
I sent you, what did I send you? You said I sent you $40 for the. No,
on your photo, the photos you sent me for what the agreement was, your exhibits 29 and 30. I'm going right down those things.
Mm-hmm.
And one of them lists the card box is $40.
So I don't understand where you're getting the $40.
Ma'am, that's where I'm getting it from. Right off of it, it says gift box or card box. $40. Where is it here? Centerpiece, $40.
I think you got it from the other person.
Reserved. Okay, so 40. Oh, maybe not. Maybe that was.
That's what she told you.
No, here it is. No, here it is. It's card box. It's on 30. It's on number 30. Card box, $40.
I don't see the $40 that you're
on exhibit. You marked it as 30.
Mm-hmm.
it says, it starts out at the top, says backdrop, curtain display, balloons, $300. Welcome sign at $50. Card box, $40. See that?
I don't.
Well, do you have your exhibit 30 in front of you?
Nope.
The picture 30 is was the agreement. So
Right. That's what I'm saying. That's your exhibit 30. That's part of that agreement. You got 2 pages of your agreement, 29 and 30.
That's her agreement. Yes.
Well, isn't that what you agreed to?
I did agree to that. But it wasn't an individual kind of thing. It was all of it, $1,800.
Well, I understand, but these are specifically listed as an amount. That's the thing. You got to bear with me. I'm going to go by what the two of you agreed to, and
all right.
Those are kind of specific listed amounts. That's all.
And she told me that her daughter does the boxes and she does a great job at it. So then I asked her in a text message, did your daughter do this box? Because the box, she would never answer it. She would never answer if her daughter did it because it looks like a kid did the box.
Yeah. Okay.
Maybe your daughter's very young.
How was the card box was sitting on a table, a gift table, it looks like. Is that right?
Yes, it was.
What did the gift, not the box itself, the card box, the gift table, what did that look like?
It just had a tablecloth on it and the box was sitting on top.
Okay. Okay. Okay.
And she did send me $100 back from through Zelle, and she said that she's sorry that I wasn't satisfied. And I told her, I said, well, it seemed like to me that you and I can communicate and we can come up with a happy medium that would be fair not only to myself, but fair to you also. And she said, as far as she was concerned, I never have to contact her again. And I was like, wow. And it just so happened that we both go to the same church. And I was so taken aback by her not even wanting to even discuss this and try and come to a happy medium. I told her, I don't want to have to go to a third party to have to decide this. And like I said, I don't have no hard feelings towards her. I'm just disappointed in what I actually received, but I don't have no hard feelings towards her, and I'm never going to say anything to anyone to try and discredit her or whatever. I mean, it's something that happened. I truly, truly do believe that she was overextended in the other thing that she had, because you don't get there to 2:30. How you going to do this? And I don't know what time she got there, but at 2:30 when I got there, she was there. But at 6, you're still there, and you said that you would the latest you would be there would be 2:30. So that's the reason why I'm coming then, because I know that once she out of the way, then the people that's taking care of the food and everything can do what they need to do. And needless to say, they were not able to do that. Everything was behind, and it was embarrassing for guests to be there. And it just, I don't know. I really feel bad about the whole thing. And it's not, she keeps saying that as if I couldn't afford it or whatever. That's not the issue.
I never said that, Miss Mary.
That's not the issue of whether or not I can afford it or not. It's just that I had a budget. This is what I wanted. This is what I paid for. This is what I expected. And then, unfortunately, what I got is not what I paid for.
Okay. All right. With that, we're going to close there. This plaintiff's last final argument. I'm going to get off, make a decision for both of your sakes, and before we can move on. Okay.
Okay.
Hold on.
Do
I'll
you
be
have
right
the
back.
total amount that I asked for? I'm
Well,
not
you're
saying I'm
asking
going to
for.
get it.
I'm going to
but
go off. Well, your complaint says 500.
Well, okay, so you don't do the
That's what I.
processing service fee and the filing
Well,
fee?
those are going to be court costs. If I give you anything, it'll include the court costs and processing, which is I've got a $50 processing fee, and I believe it's let's have it here. Your filing fee was somewhere
30.
Yeah, $30.
And
So, So I've got $80 in court costs.
Yes.
Okay. All right.
Judge, can I say something before you go off?
One quick one.
Make it fast.
Okay, as for when you're looking at the invoice where it tells you about the backdrop and the price of the backdrop, that price is included with rental of the backdrop stands, curtains, and then balloons. That's not just balloons.
Okay.
I just want to let you know
that whole
that.
setup. Yeah. Okay. All right, guys. Give me a sec. I'll be right back on.
All right.
All right, guys.
Okay, we're gonna zip forward a little bit. Oh, you should let them talk to each other. Let's see. Judge doing some higher math. There we go.
On the record.
They're just trying not to make eye contact.
Okay, we can go back on the record. I had a chance to read my notes regarding this matter, and the complaint is asking for $500 for services not rendered, or that were in such a condition that they weren't rendered. Do find that there were some items that were into Ms. Bashir's credit. She does admit that the balloon situation was not good. She did give credit for $100. I'm taking that in consideration with some of my judgment here. Do find that there is owed for the and again, this Davis Taylor. Some of this is directly off of what was agreed to with the agreement. I understand what you're saying. It's $1,800 total, but there were some items that were specifically laid out at how much you were being charged for them. Card backs was $40 plus gift table of $10. I'm giving you $50 for that item. The welcome sign, $50 for that item. I'm giving $200 for the backdrop. That did need to have more done to it. That's being offset because there was $100 given back by
$300 now
as well. I'm giving you a total in damages of $300, court costs of $80 for a total of $380 based on those items. It's hard for me and I appreciate the disappointment with some of these items, but I got to give you what was agreed to, what I can concretely say these items should be credited for. That's what we're doing here.
And she could just give you that money,
so judgment
that money
for
at church on
plaintiff
Sunday.
in the amount of $380. Okay.
Okay.
And good luck to both of you. Okay.
All right. Thank you.
You're welcome, ma'am.
Bye.
We are the champions, my friends. All right. Wow. It makes me never want to hire a decorator. Was that wrong? Was that wrong of me? I think $1,800 was dirt cheap. But in light of what she did to sort of make it right, yeah, just napkins at Son's wedding were $300. So she basically paid $1,500 for a part. Yeah. I'm not paying I'm not paying $1,500 for Halloween decorations. Let me just tell you that. Plus, I'm not hiring anyone to do it. I'm doing it all myself. So I'm going to go to Lowe's and I'm going to buy some of those tall garden stakes and hammer those in around my flower garden and put the caution police crime scene tape up. I'm doing all that myself. I'm curious how much money I'm saving by doing it all myself. Probably $1,800 is my guess. Let's see. I promise you'd love to hire a decorator if it's the right one. Legally Blonde, having said that, yes, I agree. Because when we sold our house, we hired someone to stage the house for us. And if you haven't heard of like staging a house, there are a couple ways to sell a house. One is you clear everything out and it's just empty and you let people walk through and they try to envision what they're going to do with their rooms and whether they like it or not. That's one way. And another way is to move out of the house and let somebody move into the house, everything to make those rooms look better than they ever did, and then sell it. And you're selling the idea of this. You could have a house that looks this nice and we're going to take all this stuff out before you move in. We did the second route. And I believe it did cost us maybe $5,000 out of the selling price. But it got us a lot more money for the home than we would have gotten otherwise. So, all right. Jumping down to Bexar County, Texas, where Judge Stephanie Boyd is hard at work this morning.
Knowing that, do you still wish to plead true to violation of conditions 1 and 1?
Yes.
Court will find violations of conditions 1 and 1 true. State, what are you recommending?
Your Honor, at this time, State is recommending that you grant State's motion to revoke, enter an adjudication of guilt, and sentence to 7 years in prison.
And defense, what are you requesting?
Judge, we're requesting continue. My client would like to address the court.
All right. Can you raise your right hand?
Ooh.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
Thank you.
All right, you can lower your hand, state your name for the record.
Austin Zachary Mark Gibson.
All right. So what do you wish to say to the court?
I just want to tell you that I do accept a full range of, full responsibility for it all, and I do apologize to you in the court, and the persons of that business. I did react like this due to, lack of consistency on my medications. I do ask that I can get the help, to get this correct. I have a meeting scheduled with Miss Amanda at CHDS.
I apologize. I'm going to ask a couple of questions and go back. Before we talk about Amanda from Center for Healthcare Services, talk about what happened. You said you were inconsistent on your medications.
Yes.
You want to be more specific?
A lot of the inconsistencies would be, getting up very early for work, like 3 a.m. I wouldn't, out, just pack my lunch and out the door. Being there's time that my phone isn't charged or plugged in, or even the noise, because my little girl would like to grab my phone.
And so you basically stopped taking medication.
Yes.
And ever since you got clean and sober, when did you get sober?
I've been sober for a good while.
Ever since you got out of Lifetime, pretty much?
Yes.
With one minor exception, but you've tested negative on your UAs since October of 2024. So basically for the last year, you've been all negative on all your UAs.
Yes.
And you successfully completed Lifetime Recovery inpatient.
Yes, sir.
Successfully completed SATIC before that.
Yes.
You had done the outpatient program before.
Yes.
Completed your UAs in the last year successfully. Done private outpatient with Lifetime, is that correct?
Yes.
And you're behind on your fees though, is that correct?
Yes. But I do have employment.
Yeah, but go ahead.
I do have employment that I can catch that up. I did have a vehicle that had a lot of issues, and it took a lot of my money, and that's why I couldn't stay consistent on the payments. But this job that I do know is a second chance employer. They have accepted me for employment.
And so since you got off your medication, that's the real problem you're having.
Yes.
And what happened with this specific incident?
It was just time of day. It was hot. I just got frustrated. I outlashed towards just an inanimate object rather than a person, and broke the fence. And I was looking for water for my radiator because I thought it was the radiator that had failed, but it was the water pump. So I tried to put water into the reservoir so that it could feed back into the radiator, but I didn't find nothing but like maybe a quarter of a cup.
So, but what happened was you were trying to fix that.
Yeah, I wanted to fix that, and I couldn't find a water faucet that worked. So I said, oh, you know what? I already broke the fence. Let me go to the roof. Let me see if I can find a run valve for the HVAC system. Well, I found one. I tried to turn it, and it didn't work. So when I stood up, I slipped, and I kicked the piping right there.
And what does that have to do with you being off medication? Talk to the judge about that.
That's just me. My mood swings have been. It's been a lot.
He was on the roof
up
of
and
the
down,
building,
and I never really understood how to talk to anybody about that. I would like to try to talk to my team there at the Center for Healthcare Service, but when I do call, a lot of the numbers, either when I call they answer and hang up, or it sounds like a fax machine, like a beep boop beep boop boop.
I have a question.
Yes, ma'am.
You're not going to
You've
like
been
it.
before me previously for a violation of condition number 1.
Yes.
And whenever there's a violation of condition number 1, that's a new charge. So what was your previous violation of condition number 1 for?
I can't recall.
All right. Could somebody look that up and tell me what that previous number 1 was? Because once you had a violation of condition number 1 for that time, the court denied the motion, and that's when you got sent to lifetime recovery. And the motion was withdrawn. So there was a previous number 1. Yes. What was the previous number?
In 2023, the new offensive assault was withdrawn on 2023, and conditions were amended to include drug court, lifetime recovery.
All right. So that was an assault. And who was the complainant in that assault?
It was my wife.
The name?
Claudia.
Yes. And now I have a letter, defense exhibit number 1, with her saying, there were some issues between you as far as you're not doing your medications.
Yes.
All right, continue. I'm just trying to get the sequence of events in my head.
Yes.
All right.
And it's just been there's not much else I could say about it. It's just, I've had a lot of, problems within myself trying to find either courage or, cry out. I'm not sure, but I didn't know that I could even come to you. A lot of people told me that I could ask you.
No, because let me just tell you, let me stop you right there. You're saying that you can't come to me. No. I don't believe that. And let me tell you why I don't believe that. And your counsel will tell you this. Everyone in this court who is placed on probation, I let them know. If they have an issue, let their officer know. If they feel as their officer is not addressing it, then you can come back to me. And every time that somebody's had a motion to revoke, if I've continued them, I tell them that. So don't start with, I didn't know I could come, because that's not true.
Yes. Yes. And my plan is to get with Miss Andrea at Center for Healthcare Service, and explain to her my, issues that I've had personally, and see who she could get in touch with, like with the care team over there that I can follow through with.
Austin, if I could interrupt you, you met with somebody 2 weeks ago from Center for Healthcare Services since you've been in custody. Is that correct?
Yes.
And when you met with her, she talked to you about if you're released, if the judge is kind enough to continue you can go to Center for Healthcare Services.
Yes.
And they will plan a treatment and care team around you.
Yes.
That's what you told me.
Yes, they will.
So it's not so much of, you're going to talk to her when you get out, but you've actually met with her. And
yes, and she's told me and 4 other gentlemen that they would do that.
Breathe, that is so good.
And so what you're asking the court.
And I'm asking the court if you could kindly reinstate. If not, I accept the full range of the punishment of my problems here.
All right. State, any questions?
Briefly, Your Honor. Mr. Gibson.
Yes.
At any point during this inconsistency you refer to, did you inform your probation officer?
Say again?
At any point during this time of inconsistency, did you inform your probation officer of that inconsistency?
It's been she's a very hard woman to get a hold of, to start with.
No.
I mean, I would like to talk to her. Like I would want to tell her things like that, but she would always say like, "Oh, that's not for me to deal with."
But my question is, did you make attempts?
Yes.
Okay. And then prior to August 31st, 2025, did you have contact with Center for Healthcare Services regarding this inconsistency? Or did you make attempts to?
Yes.
Yes. You mentioned that you were attempting to get water, correct?
Yes.
On or about August 31st, 2025, was the Wallace Bank open?
No.
Were there other businesses around?
There was a Jason Sedeli, I believe, but I had asked somebody like from the parking lot, like, "Hey, can you help me with some water?" They looked at me like I was crazy, so I was like, "I'm not even gonna attempt to."
Would you agree with me when you jumped the fence for the Wallace Bank, you had 2 jugs of water with you?
No, I had an empty bottle.
So at no point you didn't pour water on yourself throughout the time?
I poured water on myself, yes, but that was very hot water.
So you would agree you came
Yeah,
to the Wallace Bank with
yes,
water?
with water, yes. But I needed more water.
Mr. Gibson, would you agree with me the best way for someone to learn a lesson about consequences for them to take full responsibility for their actions?
Yes.
No further questions.
Nothing further.
Prosecution goes for the jugular.
Right. So probation on this case, can you tell me, was there any restitution that was due Vincent Arias and Victor Toro?
They're researching. The attorney's like, you're blowing it, man. You're blowing it.
All right. So, Mr. Gibson, what I can tell you is I read the letter from Ms. Rushing. There is nothing else I can do to help you. And let me explain to you why. This is not your first motion to revoke. And each motion to revoke that you've had with me has been your having a new case. So the first time, you're, of course, on deferred adjudication for aggravated assault with a deadly weapon. And the first time was an assaultive case against, you say, your current wife. And that motion was withdrawn. I'm assuming it was withdrawn because maybe she didn't want to come forward or maybe there wasn't enough evidence. I'm not saying either way. I'm just saying that with regards to that issue was addressed by withdrawing the motion. And when that motion was withdrawn, the first thing was a referral to felony drug court. And if you were not accepted there, a referral to lifetime recovery. And before that, you were sent to SATF. So there is, and then, well, actually, you've had more than one motion to revoke. So you had a motion to revoke in 2020. That was a violation of condition number 1. The court found that true after your plea of true. You were denied an alternate amended with a TAP evaluation follow recommendation. Then on November 2020, you're like, hey, I'm ready for treatment. Let me do it. And I said, okay. And that's when you were with your new wife, and there was supposed to be no harmful or injurious contact with her. And then after that happened, then there was a motion to revoke that was withdrawn, and they alternately amended conditions to include no contact with Claudia Rushing. And here we are with another number 1. And based upon the state's cross-examination and your answers, this wasn't about your seeking water. You had 2 jugs of water, and you actually poured water on yourself instead of pouring it in your vehicle. So as previously stated, the court is finding 1 and 1 true. The court is going to find you guilty. The court will revoke you. There's an affirmative finding of deadly weapon. There's to be no residing in any household with minors.
Why is that?
Because
there is to be no unsupervised contact with minors.
Judge, he's like, shut up, shut up.
And the court is going to have the previous conditions that were previously given. There's to be no contact with Claudia Rushing.
He didn't like that one.
Vincent Arias.
That's his wife.
And Victor Tovar. I think it's Tovar, Tovar.
He wants to talk.
And the court is going to sentence you to 10 years in the prison. The court will give you credit for any time served. Credit for any time served for successful completion. Thank you. All right, if you'll let the clerks know. Successful completion of inpatient treatment. Court will recommend therapeutic community. Therapeutic community doesn't increase the time that you're in custody. It's just to provide you with help with your sobriety. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it? All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication.
Quick question.
Sure.
That my wife is all I have up there, and I understand that, you know, what I did was wrong, but she's the only person I have.
So here's the thing. I understand what you're telling me, but what I'm telling you is based upon the allegations of your previous assault against her. You all agreed that the motion would be withdrawn, and this is from 2023, I believe. You agreed that it would be withdrawn and that there be no contact with her. So the court is following the previous condition.
Please let me at least talk with her, because that's my daughter. You know, that's my family. That's all I have.
No, in the letter that I received, she states in that letter that those are her biological children, not your biological children, that you have a biological child with someone else.
Oh, it's with her.
No, that's not what's in the letter.
With Claudia Rushing? Yes, I have a little girl, Athena Gibson.
That's not what she put in the letter.
Yes, I have a biological daughter with her, Your Honor.
Well, what I'm telling you is when you're released, you're not allowed to have any contact with her. When you're at the prison, you're not allowed to have any contact with her. You're not allowed to have any unsupervised contact with minors, and you're not allowed to reside in any home where there are minors. And that's based upon the letter that was presented to me. That's based upon your current actions.
And
wow.
Judge, could we modify that to allow him to have contact with his biological daughter?
No unsupervised contact with minors. All right, thank you.
Wow. Probably one of the strictest rulings the judge has come down with that I've watched before. That is, when she says violated condition number one, the condition number one is you should commit no more offenses. You can't commit any more crimes. 3 times he commits more crimes. Every time he comes before the court, he's done something else. He's done something else. He's done something else. And last time she said, "This is the deal. You know, here's the deal. And if you break this one, here's what it's going to be." And he broke that one, and that's what it was. So, wow. I do feel for him with mental illness and medication that he needs to take. It sounds like he was not on it and did some things that he regrets now quite severely. We're going to jump down to Judge Wolf in Tennessee, who is not in the Heavenlywood courtroom. Just 1 minute to see where it starts. I think it's here. We're going to back up just
15036, 37 and 67 on page 2. Kyle Burnett.
Judge, that's my client. He's in custody. Well, he's out of custody. We call this second call. We might resolve that, Judge.
He's in custody. Well, he's out.
14828, William
He's
Scott
escaped.
Burns. I have a note from the jail that he's an empty.
Let me skip ahead a tiny bit.
Okay. Mr. Rand.
I haven't seen Mr. Rand this morning yet, Your Honor.
I have many messages from
Mr. Carter, have you talked to your attorney, Mr. Rand?
Yes, sir. He said he was supposed to be here this morning, but I have not talked to him since.
Have a seat. We'll come back to you when he arrives.
This is a far cry from the Heavenly Wood courtroom.
5, James Tyler Dabbs.
Judge, that's also a gentleman who's in custody. Second call out.
I think those are circuit breakers in the background.
15087,
they're doors to jail cell.
Really? Mr. Davis is here. General McLeod sent me a message a while back and said that we just need a trial date on this. I'm okay with that.
She indicated that her due date for her child to be born is in January, and so she would be looking at probably asking for it to be in June. That's June when I'm coming back. So
we're going to set everything for February status date?
Yeah, put it on the February status date, but I think, and the way we left it was is that we'll put it on that February date, but it will then be assigned a trial date if it's not resolved. So February would be the February 10th.
Okay, thank you, Judge. And Mr. Flanagan, I know this is going to be a shock to you, but he asked me to let you know he was going to be late.
Who?
Mr. Flanagan.
Who?
Yeah, I know.
Mike Flanagan will be late.
15069A, Candy Diaz.
No, that's my motion to withdraw. The reasons for which are outlined in the motion. I no longer have any cases in this criminal court, and I've also worked with Ms. Diaz before and was forced to withdraw at that point as well.
I've withdrawn from this client previously. Was forced to be withdrawn from her case previously, and now I need to do it again.
All right, Ms. Jackson Smith, we're going to allow you to withdraw from this case. And we'll appoint Mr. Mark Atchison.
Crystal, he's late.
County Board to represent this defendant. So,
I will draw the order, Your Honor. Thank you.
thank you. Ms.
Those are prison cell doors.
Your lawyer will now be Mark Atchison, who's in Dixon and Charlotte, Tennessee. You need to, he's with the Baker Law Group. One of his partners is here. So you need to make sure that you contact Mr. Atchison and let him know that you are now his client. Is this set for any status?
This was the status statement.
All right, put it for the February the 10th for status. I put it on February 10th, Mr. Baker, for status for Mr. Atchison to be able to resolve it. Mr. Jackson Smith, if you have any discovery, would you make sure that Mr. Atchison gets that case?
Yes, sir, Your Honor. I will.
All right, thank you.
Thank you, Your Honor. Have a pleasant rest of your day.
Judge 15069B is the co-defendant's back Crescencio Diaz Acosta. That's for an attorney status and status.
Crescencio Diaz Acosta. Good morning. Do you have a lawyer?
I don't have an interpreter.
Here, Ed Penn, I think those signs. I think the signs are bail bondsmen. They're advertisements. They're advertisements for bail bondsmen, I think.
That's our bail conveyance. Yes.
All-Star.
Mr. Diaz Acosta, we need you back here on October 21st at 9 a.m. You'll write that on a card. We're going to give you a card. We'll have an interpreter on that day, and you need to be here then.
See.
What's it like?
15071 Joel Donovan.
And Mr. Don, is he that's Mr. Knowles' case? I haven't seen Mr. Knowles yet.
Have you spoken to your attorney, Mr. Knowles?
I have. His secretary called me and said that he would be on a Zoom with you today.
On Zoom.
Crystal, are you from this neck of the
understanding was
woods?
yesterday
First
he was
County?
out of town.
She had contacted me and said he would be on a Zoom.
But apparently he is going to Zoom in for vacation, but he is not in here now. You may want to contact him by phone, let him know that he needs to come in on Zoom. So we'll pass your case until I can hear from Mr. Knowles.
You want me to call on your honor and come back up here?
You can do that.
Give him a jingle on the old
You
telephone.
don't have Mr. Knowles.
Yes.
He probably needs to let the clerk contact him because he needs to log in information. So if you'll just have a seat.
15088 Elizabeth Drucker for an attorney status. She has a trial date next month.
I'm sorry, repeat that.
She has a trial date next month, November 15th. This is her attorney status.
All right, this is the day that you were to let the court know who you've hired as a lawyer because you have a trial set on November the 14th.
I wasn't able to. I don't have funds to hire one. I thought I was going to have help, but I wasn't able to find help to hire one.
Raise your right hand and place you under oath.
You solemnly swear or affirm that the testimony you now give shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes, ma'am.
We're going to give you a form to fill out that's called an affidavit of your income and expenses. What that will do is to let me determine whether or not you qualify to have an attorney appointed. If you do, then I can appoint an attorney for you, and that attorney will leave, obviously, as quickly as possible to get ready for your trial next month.
Yes, sir. Do you have a pen?
Next month.
There's some in the back, Judge, in the cup.
The trial's going forward next month, and the attorney, public defender, getting thrown onto the case. It's pretty quick.
I told her she was in charge.
15072 Brendan Dewar.
Brendan Davon Dewar.
Oh man, Crystal.
Sorry.
We don't normally go back and watch
$3,500
older
bond with
trials.
NBA bonding.
But there'll be a conditional forfeiture of the defendant's bond in the amount of $3,500. Sarah Fisher of the bonding company. We need to set it 6 months down the road for final.
He's a little hard to hear in this one.
April,
He's mumbling.
I'm here. April the 28th.
I'll be over there.
April 28th will be for the final forfeiture. Capers for the Sarah Fisher of the bonding company. The final forfeiture set for April 28th. The defendant, capers for the defendant's arrest, move on will be $10,000.
Yes. 14864 William Keaton Hall.
He's moving right through these.
Your Honor, I represent Mr. Hall. That's today for status. It's been set, I believe, last June, and now we've set it for today to get a trial date.
We need a
So
trial
we have
date.
it set in February.
Are you wanting it set in February?
I don't think you can give us enough days for it to be heard. It's gonna take a week.
One thing about next year's calendar that I've already determined is it is fluid. And that means that we,
My understanding that General McLeod will be out for maternity leave during February. I don't know what else.
It's not her
is being
case.
tried. I understand.
So there's no more than 2 days.
the Phillips case is Phillips versus Three Rivers. That's the one that was yesterday, and the plaintiff's attorney is. Can we tentatively set it for, my understanding is you're gonna be looking at 3
And
to
I think
4
we can do it
days.
in 4. I think.
What about the 17th through the 20th? Let me tell you why. I have a civil case that I assigned months ago to trial. That's a jury trial. It's medical malpractice, I think. And the plaintiff's lawyer is undergoing cancer treatment. And as of the 17th of this month, he'll know whether or not his prognosis will allow him to try that case or if it's going to have to be pushed. And all sides are agreed that if his prognosis doesn't allow him to try the case, that they'll agree to reset it. I'm of the opinion that likely it's not going to go in February. So I could give you that tentative trial date if you think that is a day that would work.
Well, I believe there'll be a need for a motion day before then. But there's a date in February that you have motions.
And then we can give you a motion days on the 10th, but if you need them further out.
Oh, that's fine, Your Honor.
I mean, the only question, Judge, I don't know what kind of motions, so that may or may not be.
We might jump to another one.
An issue 7 days before trial. I don't know when he's filed. And I'm not saying anything bad about Mr. Mitchell. I just, as you know, that could.
Sounds like he's been critical of me.
Not at all.
Codington County,
is
South
there any
Dakota?
reason we couldn't hear, as you know,
I don't think
we
we've
have
ever
one
been there.
courtroom here, so it's kind of difficult to hear motions.
Let me jump out of this one.
Term of court,
sorry,
unless
Judge
we
Wolf.
agree to hear them.
We've got to bail. Let's see if we can. We've got a lot of courts happening right now. We're just trying to find something that's really interesting that we can jump in on. Let's see. We've got Judge Raquel West, Judge Humphreys. We just left Judge Wolf. Sorry, that's the Humphreys County. Judge McNally is.
She's currently living in Tampa, Florida, Judge. Very briefly,
We're not going to go there. Let's see, Judge McNally, Judge Burney, can't do that one. Judge Middleton. Let's see, let's jump here.
Yeah, so I'm inclined to reach out to Mr. Maida and explain to him
I will explain
about the no driving, because I know Mr. Maida is the one that helped get him that vehicle in the first place that ended up, I think, part of this wreck. But when I say no driving, it doesn't mean in a couple of years I get some request that, hey, he's been doing great, let him drive. You're either riding with someone or you're on a bike or whatever else, or walking. And that is the most serious part of what I want and need to do to make sure that the community is safe. Do you understand?
Yes, ma'am.
Okay. I don't see the certification. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm.
And consult a lawyer.
If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, Mr. Gayden. I hope you take advantage of this. Don't make me regret it, please. Okay.
No driving.
Mr. Rojas, you've got Loetha Magruder.
I don't know if you hear, she told me this morning she's looking at hiring a lawyer in Houston.
Let's get Ms. Magruder out when you have a minute. And, well, I'll do this too. Let's see. What is Ms. Pratt's onset at now? I might can figure it out. Let's see. Well, you never know. What's she charged? Eight. Good morning, you're Louisa Magruder?
Yes, ma'am.
And Ms. Magruder, Mr. Rojas told me this morning that you have the intention of trying to hire an attorney?
Yes, ma'am.
Okay, so I need you, if your family or you is going to do that, I need that done within the next 30 days.
Yes,
I'm gonna reset your case one time. Obviously, I can't have you just sitting in jail while we're not doing anything on your case. And so Mr. Rojas will remain your attorney until or unless you hire someone. If for some reason it doesn't work out that you hire someone before that next court date, then we're gonna move forward with Mr. Rojas, okay? Okay, you can go back with the bailiff.
That was
Thank you.
quick, super quick.
Ms. Pratt, come up, please. Ms. Pratt, why won't you give me your analysis this morning?
Well, that's the same thing we went through last time. That's why I have the patch, because I found out that I have a tumor in my kidney.
Okay.
While I was in jail, so that's why I can't urinate.
Okay. Because I have notification.
The lady came from Vienna to put the patch on. It was real late at night in jail.
So I have notification dated yesterday, the 6th, that you got a drug patch on August 31st when you were in the jail, and that they haven't seen you back to change or put another patch on you.
2 weeks ago, they didn't tell me to come back to check. They didn't give me a date or anything.
I don't believe
I
that.
thought I was coming today to get it taken off when I came, or yesterday.
That's not what that's not true. So I'm going to
I
find.
had the paper at home. I didn't bring it with me.
Well, you didn't show up yesterday, you didn't bring what you needed today, you haven't got your drug patch changed, you won't go to the restroom.
Well, she said 2 weeks.
Right.
You change it.
Yeah.
Yeah, so it's been that right now. I was going over there when I left court. I was here yesterday. I was in the parking lot.
You being in the parking lot doesn't do any good, because I'm not in the parking lot, am I?
Right.
Okay.
Yes.
Your criminal history is prior felony possession of controlled substance cases. The fact that I have notification that you have not changed the patch like you're supposed to, and that you, in my opinion, appear to be potentially under the influence of something this morning. For the record, it looked like you were sleeping, having trouble staying in your chair.
I've been up all night crying.
Okay, I'm going to raise your bond this time for violating your condition of your bond that you have a drug patch and have it changed every 2 weeks in the appropriate way. I'm going to raise your bond to $20,000. Condition of that bond obviously is that you have a drug patch. You got to figure out how to do it. You have to figure out, ask the questions, get it changed the right way at the right time, and then we'll see what happens from there. You can go back with the bailiff.
What is a drug patch? Is it a drug?
On
24/7
Aleem St. Clair,
testing?
we don't need to bring him out. That is Mr. West case. He is in trial, and this week announced that he can be ready next week if needed. And Ms. Malfino, I know that you're working on that as well. So I'm going to number the case. If anything changes after discussions, obviously with Mr. Lewis and co-defendants and things like that, let me know, and then I'll take all that into consideration when I number that case.
I will do it today.
Thank you. Yes, ma'am.
Top of page 3, Bradford Tracy hired, he's here, hired Marcus Wilkerson.
Okay.
But he told Brittany he didn't know his family hired Marcus and he wants to flee today. So Brittany's asking if you can bring him out and talk to him. So I don't know how to handle that.
I can, and can we get in touch with?
Is this about to go to trial?
No, he's not. He has a migraine. But he will be here this afternoon. He's trying to get better.
It's
Has he
a
filed
little
a
bit
notice of,
politics.
He did, Judge, last week, and I did not see it on my report, so I had not put
think I
him
can do that
in as the
easy.
attorney. Now I
But he
have.
did file it.
He did, yes, ma'am.
Need more pickles.
Stafford said he wasn't aware that his family hired anybody, and so he's ready to get out of jail, because the offer was probation. And he was just like, I want to prove, but I was like, your family hired somebody.
Yeah, it's gonna be wild.
Maybe can we keep him and deal with it this afternoon? Or?
Well, because it's really up to him. I appreciate that his family did that, but I mean, it's his choice, I guess, of attorneys.
I can't tell if you can see this. I'm gonna.
Yeah, let's get.
But I need to change it back to her if you're gonna let them sign. Let me
Patch cloth
see if
sweat for
Mark
10 days, then tested.
Yeah, just let him know, and he probably isn't gonna have any opposition to that if, and then if he's done some work, they can work out the contractual stuff, but see if he'll answer. He might be not able to. Let's just hold
Stephanie,
on Josie for a minute.
Is it something we'd be allowed to stream? A bad dog bite case today?
Ms. Holmes, you have, Michael Berlick.
Colorado's been a tough one. Sometimes their rules are great and sometimes they're not.
Upstairs, I'm gonna go get it.
Okay, thanks. Okay, thank you.
Yeah,
She's
I know.
gonna-
It's upstairs, I'm going to, I promise. I'll bring it back down.
sorry, I heard.
Good morning, sir. Are you Michael Berlick?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You will, Your Honor.
And it's just the lesser Class A theft, correct?
Yes.
Mr. Berlick, in clause number 25, DCCR 0003, the state has elected to proceed on the lesser included offense of a Class A misdemeanor theft of property from June 24th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Berlick is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor theft of property. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir.
That Colorado court is on WebEx, but they have a very strict. We're going to sue you.
Yeah, just wait right there
contempt
for
of
a
court
second.
proceedings
So the
if you
bailiff is
rebroadcast this or record it.
Ready.
My eyes hurt so badly. I think they're red to match my shirt. I think I'm going to Uber me some
He's been done.
Stevens Gourmet Hot Cocoa. I'm dying here, guys. I'm sorry.
Nakia Brandon.
No, it's a cold.
This is, we're waiting on the.
Mr. Smith. Nakia Brandon.
So we were waiting on to see if the investigator could get the affidavit from a co-defendant. Troy, he said he's unable to do it, so Philip said it's okay for me to, get the affidavit from the co-defendant. It's Almeda Miles, she pled a few weeks ago.
Okay.
So that, at that point, Mr. Brandon's case can be disposed of.
Okay.
So I'm gonna go to the county jail this week to get that affidavit done.
So I'll just do a 2-week reset. If
Okay.
something happens prior to then and you get what you need and it's gonna go away, you can come down and he'll come down any day and take care of that.
Okay.
Otherwise, we'll see where we are in 2 weeks. We'll reset Nakia Brandon. Robert Davis.
That's a competency?
That, Judge,
He's not here.
he's not here. Tim is going to have to do an extension. We don't have to report that. And
Okay.
He expires on the 10th, so.
Okay, I'll sign that extension when it comes across my desk and then we'll wait for that report.
Okay.
Jasmine Hancock.
We don't, he's wanting, well, he's requesting a trial, but he wants me to petition for a bond reduction first. So if I can give maybe a week and I can file a motion for a bond reduction,
Okay.
so formal motion.
Sure.
I talked to Mr. Hoffpower about it.
Okay, let's do 2 weeks. That'll give you plenty of time to get that filed and the state time to prepare on anything they need with regard to a bond hearing.
We're checking on, Josie. It's not external.
Mr. Parker, on Robert Hebert. We seen or heard from Mr. Kimler this morning?
He was in drug court and he resolved that case and he's on his way.
Okay. Good morning, sir. Are you Robert Hebert? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hebert, in cause number 25 DCCR 0740, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements from February 11th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Because do what they charge you.
Okay. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
The paperwork on the tablet, did y'all go over it? And do you fully understand that?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
That's correct.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Thank you, Cindy. Appreciate
State
it.
tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Hebert is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of failure to comply with sex offender registration requirements. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws,
the devices that qualify as a firearm are those that are actually firearms. I'm like stuffed up. My head hurts. My eyes hurt. I just need to go to bed, tuck a blanket up to my chin, and shop for Halloween decorations. That's all I need to do today. I'll be back tomorrow to sing happy birthday. How about that? We'll do that for sure. We're going to be back. No birthdays will be skipped. on account of my feeling pathetic. But we are hopeful to get a large case here soon, a full-size big court case. Tomorrow, obviously, being hump day, halfway through the work week. We're excited about that. Thursday, podcast day. We might have a trial from Thursday and Friday out of, I'm not sure if it's Thurston or out of Clark County. I think he's out of Florida. I'd have to check and see where we're at there, but a couple-day court there. And then soon we'll be back with some big cases to follow for, a week or two at a time. So thank you for all your generous, oh my goodness. Grit Grinder, shut it down early and rest fund. Thank you, Grit Grinder. I will do that. If we all leave Recovery Addict, since we're going on strike for, hang on one second. What's this say? If we all leave, since we're going on strike for our orders, you have no choice but to call it an early day. That's the worst way to end it. Everybody leaves. DSN, get some sleep. I will. Off to bed with me. I think I will. I think I am going to Uber some hot chocolate. Chicken soup is great. I realize, here's what I'm going to do. DoorDash, saltine crackers, chicken soup, and Steven's Gourmet Hot Cocoa. Or maybe Mrs. R.A. will run and get it for me. Better not skip birthdays tomorrow. Of course not. Of course not. We'll be back. Thank you very much. Oh, my goodness. More. Lindsay Bay, thank you very much. I'm going to get some rest. And the Bay County, Florida. That's where the court case is, Thursday and Friday. Portal us to Trial TV. We can do that for sure. Let's see. I want to give a shout out to Trial TV, helping us out quite a bit. Give me a second to get the portal set up, and we will all, well, most of us will go. I will not. I'm sorry. I will not. I'm just gonna like crawl up to bed and call it a night. Usually a day under the weather, and I'm much better. So let's see. Trial TV Live. Here we go. They're covering the Ohio versus Bianca Ellis trial. This was a stabbing that took place at a store, I believe. So a very interesting trial. We're going to portal over them to them. Here are the rules. This may not be the case you want to watch, and you might want to watch something else with somebody else. But if you can do this big favor for me, Chris and Aaron are good friends of mine. Trial TV Live. We work together. They've helped me out a ton. They made the counter that we use all the time. They're wonderful, and they're just more than generous with the video that they've acquired and everything else. So when you land there, you don't have to say anything in chat. Just click the like button. If you do stay, please feel welcome to stay. They're absolutely incredible. They do wonderful work. I'm wholeheartedly behind what they do as far as transparency and providing access to courts. They get access to a lot of really cool courts. And sometimes we cover the same stuff, sometimes different. It's just great. So tell them hi, click the like button, subscribe if you haven't already, and then you can chat. But in that order. So let me hit the button, make it official. All right. Yeah, I want to see, we've got 738 people here. I want to see the like button go up by 738. It's 39, because I'll do it too. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe. We go live tomorrow morning with a less stuffed up RA, hopefully. Fingers crossed. Thank you. I've been getting cold remedies and medication regimens in the text. I think I need to follow them all, but I appreciate it. We'll be feeling better. I don't take many sick days, so I'll take this one as a sick day. We'll do this. Thanks to our great mods. Portal incoming. We're going to jump over to Trial TV Live. I'm not even going to wait for the end of the music. You guys are great. Have a great one. We'll see you tomorrow. Bye-bye.
Because he's the guy.